I hope you can all see us and hear us. My name's Sarah Lawrence and I'm one of the barristers here at King's Chambers, and along with my colleague Nathan Smith, we're going to talk to you today on exoneration clauses and no contest clauses in wills and trusts. This is our regular Thursday afternoon 4 p.m. slot. And I certainly recognise a lot of the names, so it's great to see so many of you back and joining us. Apologies, just to admit the last few people. Nathan is actually going to start, so I'll hand over to him and I will see you all shortly.
Thank you for joining us this afternoon. I'm always surprised by how many people turn up on a nice sunny afternoon to listen to talk on trusts and probate, but as I say, it's nice that everyone can join us. I'll just start by sharing my slides. Which you should be able to see. Yeah, so this afternoon I'm going to talk about exoneration clauses, and the first question, of course, is what are these clauses? I take it everyone can hear me and see the slides. Can someone just nod and say yes if they can? Great. So what are these clauses? Well, there are several different types. They're not all exemption type clauses. You can have clauses that expand the powers of trustees or executors. You can have clauses that reduce their duties. You can also have provisions that increase the rights of indemnity from the trust. And then, of course, you have what we commonly, or more commonly, think of as exclusion clauses, namely ones that exclude liability for breaches of duty. So an example of one that expands the powers of the trustee is perhaps one that gives the trustees power to carry on a trading business or increases the powers of investment that they might otherwise have. And a pretty common example of a reduction of duties is a provision limiting, for example, the duty to interfere in or supervise the management of a company in which the trust is a substantial shareholder. And you can have clauses, for example, that limit the duty, so there's no duty to interfere unless the trustees have actual notice of dishonesty or misappropriation by directors. That's limiting, in effect, the duty that is imposed by a case called Bartlett and Barclays Trust, a 1980 decision which says that otherwise trustees should really behave like prudent men of business who are invested in a company and wouldn't just limit themselves to what they're told, but would take active steps to find out what's going on in the company. The third type of clause I mentioned, the increased rights of indemnity, well, for example, under the general law, trustees not generally entitled to an indemnity out of the fund in respect of liabilities to third parties that are incurred as a result of unauthorised acts. But you might find trust documents that give an indemnity in those circumstances. And then you also have the potential that for the final clause, exclusions of liability. And indeed, they're different, of course, to the first two types because in a case where there's an expansion of powers or a reduction of duties and the trustee acts in accordance with that, there's no breach of trust. And of course, if it happens to be some sort of breach that gives rise to an increased right of indemnity, then the indemnity becomes available. The last type, the exclusion clause, is a different type of clause in that it applies after a breach of trust has occurred, and it takes effect generally to avoid the trustee having a personal liability to pay compensation. So there is some overlap between the third and fourth types of clause. For example, if a trustee does make an unauthorised payment out of a fund, it may be that they, rather than relying on their right of indemnity, can rely on the exemption clause instead, so to resist the claim for the repayment. But there are some quite firm limits to what can be excluded. And of course, you can see the principle behind that, because if all of the duties could be excluded, there'd just be no trust at all, and the trustees would have no liability to anyone. And the leading case on this is a case called Armitage and Nurse, which is a Court of Appeal decision that says that there is an irreducible core of obligations that cannot be excluded. But that core doesn't include duties of skill, care, prudence, and diligence, but does include the duty of good faith, which can't be excluded, and nor, in fact, can the duty of to act honestly. So there is a limit, and that limit really is that fraudulent acts cannot be authorised. And there's another point that's always worth bearing in mind, is that you can't, as a trustee, consciously rely upon an exclusion clause either to get you out of trouble when you're committing the act. They don't generally apply. So a bit more on the leading case. Well, this is the Court of Appeal decision in Armitage and Nurse. It's not, as you note, a Supreme Court or House of Lords decision. So this isn't law that's been tested at the highest level, but nonetheless, it is fairly settled law nowadays. And what happened in Armitage and Nurse was that there was some settled property that consisted largely of land farmed by a company, the directors of which were the mother and grandmother of the beneficiary, who was the claimant in the claim. And under the settlement, the beneficiary was contingently entitled to a share of the fund at the age of 40, but following a substantial fall in the value of the land, the beneficiaries claimed the trustees were in breach of their obligations to manage the fund, and a substantial loss had been incurred as a result. Now, the clause that the trustees relied upon to get them out of the mess that they were in was clause 15, which said that no trustee should be liable for any loss or damage which may happen to a fund or any part of it whatsoever, unless such a loss or damage shall be caused by his own actual fraud. Now, claims by the beneficiary that the clause was void for repugnancy or contrary to public policy, they were rejected. And what the court held was that it was effective to exempt a trustee from liability for loss or damage, no matter how indolent, imprudent, lacking in diligence, negligent, or willful he may have been, so long as he didn't act dishonestly or fraudulently. So the terms of a trust, or indeed the terms of a will, can exclude liability for everything except fraud. But what does that mean in this context? Well, at the minimum, what's meant by fraud is an intention on the part of the trustee to pursue a particular cause of action, either knowing it's contrary to the interests of the beneficiaries or being recklessly indifferent as to whether it is contrary to their interests or not. And as Lord Justice Millett said in the Armitage case, it's the duty of a trustee to manage the trust property and to deal with it in the interests of the beneficiaries. And if he or she acts in a way that which does not honestly believe is in their interests, then that is acting dishonestly. And it doesn't matter, in fact, if the trustee stands to gain personally from the breach of duty or not. And therefore, a trustee who acts to benefit third parties, for example, is nonetheless acting dishonestly. There are some points to remember, though. Whenever you make an allegation of fraud against anyone, there must be credible evidence to do it on. But it also has to be particularised in a way that's inconsistent with honest conduct. So you can't merely add a string of facts and say this was a breach of duty, and also add on the end these are also consistent with dishonesty. It has to be something that can be pleaded so that it's only consistent with dishonesty. And it also follows from that, of course, that a deliberate breach of trust isn't necessarily fraudulent if the trustee does it honestly believing that it is in the interests of the beneficiaries. There is, of course, a limit to that principle, and that's set out in the Walker-and-Stones case. And indeed, if no reasonable trustee could have taken the view that what was done was in the interest of the beneficiaries, then it will still be fraudulent, irrespective of whether or not that particular trustee happens to believe he or she was acting honestly. So what sort of regulation is there? I suppose that's the next question, because if there is scope to exclude the duties of a trustee to such an extent, you might think that there'd be some statutory limit on it. Well, the Court of Appeals considered whether UCTA 1977 can apply to trusts and decided that it doesn't. And that's the case of Baker and Clark, a 2006 case. Now, there are specific cases of trusts where there is a higher statutory duty. And some examples included in finance, for example, with unit trusts or pension schemes, and indeed under the Companies Act. Company directors are often treated as trustees of the company's assets, and it's not possible for them to contract out of their obligations as a result of, I think it's section 232 of the Companies Act 2006. There was a push for statutory reform of this area, but that took place back in 2002, and the Law Commission published a consultation paper at the time in which it recommended that, perhaps unsurprisingly, that trustees shouldn't be able to rely upon these sorts of provisions in trusts that exclude their liability for negligence, and that actually what should happen is that there should be an insurance-backed system where trustees applied for and obtained insurance using the trust funds to do so. But that proposal was actually abandoned when the Law Commission finally reported in 2006. And instead, what was recommended was that a professional rule of practice should be adopted. And some professional bodies have adopted that rule. I mean, it probably is a good rule of practice in any event. I know that STEP has a specific rule that follows this sort of principle. And that's generally that any paid trustee who wants to rely upon an exemption clause when drafting the document under which they'll eventually become a trustee, or a will that they'll become an executor of, should make sure that they bring that clause to the attention of the settler or the testator. There is a Court of Appeal case where arguments about what should or shouldn't happen when a solicitor doesn't do enough to bring that clause to the attention of the testator were ventilated. That's the case called Borg and Raper that's on the slide, 1998 decision. And what happened in that case was the beneficiary brought an action against the trustees and executors appointed under her husband's will, claiming they were in breach of their duties by failing to take appropriate action to prevent the main assets of the estate becoming worthless. And the beneficiary also contended that the first defendant, who was a solicitor, had obtained a benefit under the will in the form of an exemption clause, that they were in a fiduciary position and they were obliged to establish that the testator had received full and independent advice. Otherwise, it was said they couldn't rely upon the clause. Now, those arguments were largely rejected for a variety of reasons. Firstly, the exemption clause, it was said, didn't confer a benefit on the solicitor, but merely defined the extent of the potential liabilities. And it was also confirmed that the solicitor could, in any event, derive a benefit under the will, at least in the form of an exemption clause, provided the settler knew and approved of the clause in the terms that it was drafted. And of course, because in this case the will was admitted to probate, it was presumed that the testator knew and approved its contents in any event. It is, though, still, I think, good practice to explain to a client, especially when drafting a settlement, and to highlight, well, obviously to explain what the terms mean, but to highlight in particular, and to have a note that it has been highlighted and understood any exemption clauses. Now, the next question that always crops up when dealing with anything slightly unusual in exemption clauses is how to interpret them. Well, the answer to that generally is that you interpret them in the same way as any other contractual provision or provision in a will, but they are also construed restrictively, so that anything that's not clearly within the clause is generally treated as being outside it. The burden is on the party relying on the clause to show that its words refer to the conduct that's been called in question. Sometimes you hear arguments about contra preferentum and whether or not that should apply, but it's actually of limited relevance in this situation because, of course, the drafter or the person executing the trust is usually the settler, and there's no real reason to construe a clause in favour of a trust beneficiary who's not a party to the instrument as such. But where clauses are too broad, they can also be read down to make them valid, and an example of that is the Midland Bank trustee case that I've referred to on my slides. So what about some recent cases? Well, there's quite an interesting case in the Court of Appeal, a recent Court of Appeal case called SOFA and Swiss Independent Trustees that is well worth bearing in mind if you find yourself involved in pleading or indeed resisting a case involving an exemption clause against trustees. Now, what happened in this case was that the claimant's father had created a discretionary trust intended to benefit the claimant. The father was named as a specified beneficiary, and the trustee provided that during his lifetime, the trustee could lend monies to beneficiaries from the trust, but could not make outright payments to them. And the trust deed included an exoneration clause excluding the trustee's liability for loss, except where such loss was caused by acts done or omissions made in personal, conscious and fraudulent bad faith by the trustee. Now, over 10 years, the trustee paid some $61 million, representing the bulk of the trust's assets to the father. Although the payments were recorded as loans, no provision was made for security, interest or repayment. And the father repaid much of the money to the trust, but when he passed away, about $19 million was still outstanding, which his estate was unable to repay. The claimant beneficiary brought proceedings against the estate of the trustee, alleging the payments were outright payments made in breach of trust. And the trustee applied to strike out the claim on the ground that it didn't sufficiently plead a case of dishonesty so as to overcome the exoneration clause that was incorporated into the settlement deed. And that strikeout was actually successful at first instance. Now, the Court of Appeal overturned that decision and permitted the claimant to amend. But there are 2 points I think that are worth taking from this case. The first is that it's very important to consider carefully how allegations of fraud are pleaded, especially when there are exoneration clauses that exclude liability for anything less than fraud. Because if you plead a case or set out a case that is consistent with honesty, then it may well be struck out. And the second point is that the Court of Appeal reaffirmed the test for establishing a dishonest breach of trust by a professional trustee. That's a test that's also set out in a case called Fattle and Walbrook Trustees, a 2010 High Court decision. And as I said earlier, what the claimant has to show is that there's been a deliberate breach of trust by a trustee who knows or is indifferent to whether the breach was contrary to the interests of the beneficiaries, or whose belief that the breach was not contrary to the interests of the beneficiaries was so unreasonable that no professional trustee could have held it. And the second case I'll just mention is Barnsley and Noble. This is again a Court of Appeal decision, but it's from 2016. But in it, the Court of Appeal had to consider the proper interpretation of a standard form exoneration clause that was contained in a will. And the court held at first instance that a trustee was covered by an exoneration clause, which stated that no trustee should be liable for any loss to the trust arising by reason of any improper investment made in good faith or by reason of any other matter or thing except These are the important words: willful and individual fraud or wrongdoing on the part of the trustee. Now, the claimant who lost at first instance appealed, arguing that as a matter of construction, the clause didn't apply to the self-dealing rule. And there are numerous other construction points taken too, none of which were successful on appeal. But there was also an appeal on the ground that the trustee had engaged in willful, that's to say intentional wrongdoing, and therefore couldn't rely upon the exoneration clause. That's to say, the appellant said that because it was an intentional act that was complained about and it was wrong, that was sufficient to make the clause inapplicable. The Court of Appeal rejected that argument and held that the meaning of the words willful wrongdoing actually required an awareness of wrongdoing too. And that was supported by the way that the word willful applied to fraud as well as wrongdoing in the clause. But what it effectively shows is that at least where that clause applies, and probably in similarly worded clauses, intentional acts that happen to be wrong will still or may still fall within the wording of the clause. Of course, it does depend on the precise wording in each case. So, in conclusion, exemption or exoneration clauses in all their various forms are clearly very important when drafting wills or trusts, and careful consideration should be given to them because they impact very significantly on the amount of risk that a trustee is accepting, or indeed an executor is accepting as part of their administration of the settlement. The case that I referred to earlier, the Bag and Raper case, makes clear that a solicitor can introduce a clause into a will where they're going to be an executor, although they should, as a matter of good practice, if nothing else, bring it to the attention of the testator. And of course, you should have a good file note that confirms that the testator understands and accepts the exclusion clause. Although, of course, once that will is admitted to probate, as occurred in the Bag case, there's a presumption that the testator knew and approved the contents of the will anyway. The other really important aspect, though, of these clauses is when considering a claim against an executor or a trustee for breach of duty. It's important to consider whether there is an exemption clause, and if so, what exactly it excludes. These clauses can often be buried somewhere in the trust document, and where they apply, it can make it very difficult to establish a personal liability for breach of trust against the trustee, at least in the absence of fraud. And as the SOFA case that came before the Court of Appeal recently demonstrates, if you do have to go down the route of alleging dishonesty, it's very important to have credible evidence to do that, and also to set out very clearly why it is in your pleadings that you say the conduct is fraudulent in the sense required. Otherwise, you might suffer the same fate as the claimant in that case did at first instance. So that concludes what I wanted to say about exoneration clauses. It's a bit of a whistle-stop tour, but I hope you find it useful. It's a summary of the main principles. And with that, I'll stop my screen sharing, and hopefully Sarah will now be able to take over and explain to you how no challenge clauses work.
Thanks, Nathan. Yes, I will share my screen now. Welcome to those of you who have joined since Nathan began his talk on exoneration clauses. We have both done PowerPoints, and they will be emailed out to you in due course, so that you've got all of those, and contained within both of them, and indeed behind us, you should find our email addresses. So if there are any issues that you have in relation to anything that you've heard today, as you've probably heard us say every other Thursday for the last couple of months, we're a very we like to think of ourselves as a very approachable set. Don't feel that you've got to have an instruction in your hand ready to send us in order to ask any questions. If there is anything that you want to discuss, whether in relation to this or any other matter, do drop us an email or pick up the phone and just give one of us a call. Hopefully I can now share my PowerPoint with you. Hopefully you can all see that. Again, same as with Nathan, if somebody, yeah, thank you. I'm grateful. Yes, the intention today is for me to talk to you about no contest clauses in both wills and trusts. You will hear me talk about many of the same principles that Nathan has just spoken about in relation to exoneration clauses, although they are applied in slightly different ways, and hopefully there isn't any significant overlap in what he has just spoken about. But what is an exoneration clause? Well, sorry, that's what Nathan's spoken about. What is a no challenge clause, a no contest clause? Well, it's a condition not to dispute a will, i.e. any condition that prevents or discourages beneficiaries from going to court. And of course, the classic example of that would be that they lose their benefit under a will, or lose a substantial part of that benefit should they dispute either the validity of the will itself, such as due to capacity or anything like that, or should they challenge their part or somebody else's part. I'm also going to talk about trusts, and of course that can be a condition preventing or discouraging beneficiaries from going to court to litigate over lifetime trusts. And of course in wills, what we often see, and many of the Inheritance Act provision for Family Independence Act 1975 claims, arise of course from a lifetime trust, perhaps to a cohabitee or a right of occupation or something like that, or the failure to provide one, and the litigation that flows from that. In general, there is no general rule against such clauses. Having said that, and that comes right the way back from Cook and Turner in 1846, which was that a condition that a beneficiary who challenges a will loses the benefit given to him by the will is a principle valid. The exception there, or the point to take, is that in general, this is at least where there is a gift over. The case of Nathan and Leonard that I'm going to come on to, the most recent significant authority on this point, reaffirmed that there is more of an argument, and again I will come on to that, where there isn't a gift over. But if there is a gift over, then in general it will be difficult to argue in principle against such a clause. So the case of Nathan and Leonard, it's only High Court. However, it has been around since 2002, and so far it appears to have been accepted as largely restating what the existing principles are, as I say, that date all the way back to the 1860s. Here we have a case where Mrs. Nathan had a 50% beneficial interest in a property that she lived in along with her friends, Mr. and Mrs. Leonard. They were friends, they weren't family, and as I say, they had 50% beneficial interest each, the Leonards having half and she having half. She made a will and then later 2 codicils. The will and the first codicil were professionally drawn up, and they left 2/3 to the Leonards of her residuary estate, along with a life interest, a right to occupy for them in relation to the home that they lived in. There was then a third that was on discretionary trust for Mr. Nathan, her son, his children and remoter issue, and 2 charities, one of which was Mind. Her son, Mr. Nathan, brought an IPFDA claim stating that the amount of provision was insufficient for him. And it's the second codicil, which she drafted herself, that created the issue. And what I'm going to do is read that out to you. It says, "As a safeguard to my wishes and to protect them from any parties be they family members or the charities, should they wish to contest or disagree with my will, then I want the following clause to override everything previously stated in my will. The following will become my will in its entirety. This, I hope, will prevent anyone from taking this case of action. I give, devise and bequeath my beneficial share in the property known as Oakwood Farm to my beneficiaries, Sally Leonard and Paul Leonard, free of any taxes, which will be covered by my estate. I also give to the above named persons all my real and personal property. Now, this final sentence that I'm going to read out is what's written, and you'll see why I'm saying that later, but it says this clause cannot be superseded and will only come into being if at any time during the life of the trust or up to 80 years has elapsed. And so Mr. Nathan had brought the IPFDA claim for further provision, but the result of that was that as he was any party, because any party had brought a claim, it was argued by the Leonards that that meant that they then got the entirety of the third discretionary trust. So Mind, who were one of the two charities, were added as a third defendant on the basis that they were not the ones bringing the claim. That was Mr. Nathan. They did not stand to benefit from his claim. Quite the opposite. If his IPFDA claim was successful, their interest under the discretionary trust could be reduced. But equally, they had done nothing wrong. They had not encouraged him to bring the claim. And yet, according to the codicil, as it appeared to be written, by Mr. Nathan, the claimant, bringing the claim, they would lose the discretionary trust because the entire amount, the entirety of the property, and also any real and personal property would pass automatically to the Leonards. And so, of course, the position of the claimant was that he was neutral because he was bringing an IPFDA claim. So whether he was merely a discretionary beneficiary for a third subject to the rights of occupation, or whether he was in fact, in essence, disinherited by his mother, made no difference in that his IPFDA claim would still be the same. And of course, one of the factors for the court to consider in an IPFDA claim is the amount of his benefit under the testamentary document. One of the points that the court looked at as well is that whether or not forfeiture would only happen if his claim were unsuccessful. In fact, Mr. John Martin QC, who was deciding this matter, had listed this as a preliminary issue, and it appeared that there had been some argument that perhaps the IPFDA net claim needed to be heard first, because if it was successful, it was intended to be argued that there would be no forfeiture. That, as I'll come on to later, is the rule or the approach that is taken in relation to trust claims. However, it was held that the correct approach is to construe the condition first. It may be possible to construe it as only applying to unsuccessful challenges, i.e., if the clause itself says that an unsuccessful challenge will forfeit a benefit under the testamentary document. But it may also be, as is the case here, that it appears Mrs. Nathan was trying to discourage anybody from challenging the will, regardless of whether they had good grounds to do it or not. So the first thing that, of course, has to be looked at in relation to a no contest clause is it a valid condition? And what Mind argued here was, much as we've heard in the exoneration clauses, is that it was repugnant. Now, having heard what you have from Nathan, you'll be aware that in principle, repugnancy is very difficult to show. Mind argued here that there was specific repugnancy in relation to them, as I've already discussed, on the basis that they hadn't mounted any challenge. They were entirely innocent and had no control over the actions of the claimant. But they also argued repugnancy in general on the basis that pecuniary legacies are often given out at the beginning of an administration and are immediate and absolute. However, if the condition were held to be valid, they could then be defeated at a later time by the commencement by somebody else, another beneficiary or an unconnected person, unconnected to them themselves. That wasn't accepted in this case, and John Martin QC, Recorder Martin QC, held that it must be truly repugnant or inconsistent with the nature of the gifts made by the will. And the example he gave is where a gift of property is given outright, carriage, clock, that type of thing, but that there is a limit that is purported to be put on that in relation to the incidence of ownership, such as that they couldn't be sold. He held that arbitrary and capricious effect is not enough. The second argument then was that mere deterrence, it was that this was an attempt at deterrence, and that there has been a long-standing in terrorem, which again I will come on to, policy that says that where it is simply an attempt to deter litigation, that should be done. However, again, it was held based on a long line of authorities that is not sufficient. It's not enough to make a condition void, particularly in circumstances where, as here, the whole point of the clause was to deter, and that if in principle these clauses are acceptable and not ultra vires, then equally mere deterrence should not be enough. What he found was that it merely added another factor in determining whether to bring or claim. Now, of course, that seems quite unfair here because, of course, Mind had no control and had made no decision to bring the claim. And for the claimant, Mr. Nathan, it made no difference to him because this was an IPFDA claim. But in any event, there is no doubt, and this case went on to consider, that the most important thing in relation to any clause, as we know, clauses of wills, clauses of trust, whether they be exoneration or whether they be no contest, is the requirement of certainty. And we know that clauses are normally drafted in these circumstances so that the termination of an interest takes effect as a condition subsequent, even if there are discretionary interests involved. And there is no doubt that the clause must satisfy the requirement that the court can determine with reasonable certainty from the creation of the interest what exact event would result in the termination of the interest that has been given. And the best quote, I think, comes from the speech of Lord Russell in Clayton and Ramsden, which is a 1943 appeal case, which said the courts have always insisted that conditions of defeasance, in order to be valid, should be so framed that the person affected, or the court if they seek its guidance, can from the outset know with certainty the exact event on the happening of which their interests are to be divested. This principle was enunciated many years ago by Lord Cranworth in Cleavering and Ellison in the following words: where a vested interest is to be defeated by a condition on a contingency that is to happen afterwards, that condition must be such that the court can see from the beginning precisely and distinctly upon the happening of what event it was that the preceding vested estate was to be determined. In all such cases, that is the test which has to be applied to the particular condition which the testator has chosen to impose. And here it was held that there was no real difficulty in interpretation. It was held that it was quite clear that Mrs. Nathan wanted to benefit her friends, and her expectation was that any challenge would be to benefit somebody other than them. And therefore anybody who brought a challenge against their interests, they would benefit by gaining in effect the entirety of her estate. However, the wording in her will, which was, in the codicil, which is, should they wish to contest or disagree with my will, Mind tried to argue that that was too uncertain. However, it was held that that was not merely a threat. It wasn't enough merely to threaten a challenge, but that proceedings challenging the will or a claim, such as under the IPFDA, was required under the wording of her codicil. And the key was held to be the potential to bring about a redistribution of the estate. The final certainty issue that was taken by Mind was in relation to that final sentence that I read out to you, which says, this clause cannot be superseded and will only come into being if at any time during the life of the trust or up to 80 years has elapsed. Now, it's quite clear that some words have been omitted from there, and perhaps not surprising given that Mrs. Nathan drafted it herself. And this was the part that did cause the judge some serious concern, mainly because it wasn't clear what the missing words would have been. And the concern was that it may have been simply clarifying what had gone on before, but it may have been trying to introduce a new requirement. And if it was a new requirement, it was unclear what that would have been. But going back to what I mentioned earlier about gifts over, the other concern in this case was that because of the words missing, it wasn't clear whether the limits that appeared to be imposed by that, the lack of supervision and the coming into being at any point, whether that was confined to the gift over or whether it in fact applied to the trust during its operation. And so on that ground, very reluctantly, it was found that this clause was invalid. There is no doubt that the court went, Mr. John Martin went to great lengths to try and uphold this clause, it being very much the line of authorities that testators' wishes should be upheld, and that it is a matter of interpreting the individual clause to see what was intended. The issue here, as I've said, is that that could not be ascertained because of the missing words. So what is the position then in relation to trusts more generally? And going back to what Nathan spoke about in exoneration clauses, what about if there is a clause that provides for forfeiture of an interest on a challenge to a decision of the trustees? So not a challenge to the will or the trust itself as being valid, but to challenging the decision of the trustees under that will or trust. There appears to be little doubt that in general that would fail for uncertainty if construed literally, because what is a decision, what is contesting? If a distribution is made strictly in accordance with the provisions of a trust, is that a decision or not? And so the line of authorities make it clear that it should be construed so that the forfeiture only takes effect if there is an unjustifiable challenge to a decision of the trustees. For example, they did not take a decision, it was simply their obligations under the trust, or that the decision was not, the challenge to the decision was unjustifiable, whether or not because there's an exoneration clause, or as Nathan has said, because perhaps an allegation of fraud was made in circumstances where that was unjustifiable. So there does appear to be a distinction between a clause providing for forfeiture on a challenge to the will or the trust as a whole, and where the issue of justifiability doesn't really place, and where it is simply the decision of the trustees. I've put a slide in here on the terrorem principle. I won't read it out to you. I've put the authority there if you want to look at that in more detail, but it is really this principle that provides this distinction between a will and a trust in relation to whether or not the justifiability or not of the claim that is being made is relevant. And what is clear, as I've said to you from the Nathan and Leonard case, is that the courts will, in principle, decline to determine whether or not a claim challenging a will or an IPFDA will be successful or not, or has any basis of real claim before determining whether or not the forfeiture would kick in contrast to a trust where that is the starting point. And the main case on this is actually a Grand Court of Cayman Islands case, AN and Barclays Private Bank. And in this case, the claimant was the primary discretionary beneficiary who was unhappy with the actions of the trustees. And she took action challenging a restructuring of the shareholdings held between the trustees. They relied, or the trustees sought directions from the court in relation to a clause that was in, there were in fact two trusts, but this came within both of the trusts. Whosoever contests the validity of this deed and the trust created under it, of the provisions of any conveyance of any property by any person or persons to the trustee to form and be held part of the trust fund and of the decisions of the trustees. So here we have both the classic no challenge clause in relation to the validity of the deed and the trusts, but also here in relation to the decision of the trustees, shall cease to be a beneficiary in any of these trusts and shall be excluded from any benefits, direct or indirect, deriving from the trust fund. And so what Barclays argued straight off was that the very fact that she had brought the claim challenging the restructuring of the shareholding automatically removed her as a beneficiary, meaning therefore that her complaint couldn't be considered as she was no longer a beneficiary. And they sought directions from the court in that regard. What the court said was that the court must be able to anticipate from reading the clause, again, precisely and distinctly, the event that might cause the forfeiture, that public policy didn't prevent enforcement. Here we had the position that there was certainty in provision against contesting the validity of the trust. If I go back onto the previous slide, as we said, whosoever contests the validity of this deed and the trust created under it, that was sufficiently certain. However, the section where it says, and of the decision of the trustees, was found not to be sufficiently certain. It went on in that case to find that challenges had to be made with good cause, and that clauses should not be used as a method to protect an illegal or invalid disposition or prevent challenges that were based on probable cause or good faith. Again, if we go back to the talk that Nathan made, where exoneration clauses and the distinction with fraud and whether or not trustees can be exonerated from fraud, it is to some extent the reverse. Claimants who want to bring challenges need to make sure that they have probable cause, that they're bringing them in good faith. Otherwise, they will not be allowed to, or they will be found to have breached that trust. But again, coming back to the exoneration clauses, trustees cannot be exonerated from their core obligations, and it would be contrary to public policy to hold that beneficiaries cannot justifiably enforce trusts. So moving on generally to public policy in relation to both trusts and wills, that as we've said, there is no issue of repugnancy if it provides for termination of an interest upon an event which is not dependent upon the exercise or non-exercise of any rights attached to the interest. The classic example, of course, being a termination of an interest brought about by an IPFDA claim. And the real reason for this is that the public policy behind wills and trusts is that the disposition of one's estate is a matter of private policy, and that the policy in general is that we uphold testamentary freedom. And IPFDA, as we know, is really the only exception that we have here in England and Wales. There is no forced heirship or anything of that nature unless it's contained within that. And there is no issue if the clause takes effect upon a challenge to the validity of the trust themselves or the transfer of the property into the trust, unless the challenge is unsuccessful and unjustifiable. That is what is required. However, it was held and is held that it is an issue of repugnancy where there is a termination forthwith of an interest of a beneficiary who seeks to vindicate his interest by the commencement of proceedings against the trustee. I.e., if one is merely seeking to uphold what they are entitled to under a will or a trust, i.e. there hasn't been a distribution to them and there should have been, then of course there would be repugnancy in that, in essence not being a decision of the trustee, but something that they in error have chosen not to do. So what about a situation in relation to reinstatement powers? Well, can the court have reinstatement powers? The answer is yes. Relief from sanctions, definitely a talk for another day in relation to relief from sanctions generally. But as the court has inherent jurisdiction to give relief from sanctions, it also has the inherent jurisdiction to give relief against forfeiture, which takes effect as a condition subsequent, but not a condition precedent, even though there is a gift over. Again, there is a long line of authorities, and I'm sure many of you are familiar with them, in relation to conditions precedent to taking under a will. But here, of course, we are talking about conditions subsequent. However, again, in the Nathan and Leonard case, it was held that whilst the court does have inherent jurisdiction, the line of authority shows that it shouldn't be granted where a beneficiary has deliberately acted in a way that incurred a forfeiture with notice of the clause, i.e. had had all of the beneficiaries chosen to do it. Here, of course, it wasn't Mr. Nathan who had chosen to take the action who was affected by it, but it was still said that even though they weren't complicit, there was no guilt attached to them in relation to bringing the clause, that it still wouldn't have been granted, that is, relief from it, as it would do damage to the intentions of Mrs. Nathan. It was said that she had contemplated this result. She was aware of how many beneficiaries there potentially were, and by making it clear that any party bringing any challenge to her will would in essence pass the entirety of her estate to the Leonards, she must have contemplated that there would be innocent beneficiaries who would be affected by such a position. And therefore, although it became redundant because, as we've already heard, the clause wasn't held to be valid because of the uncertainty of the missing words, the court still went on to consider that. And there's no reason at this point to believe that that isn't a good summary of where the Court of Appeal, and indeed the House of Lords as it then was, had reached in relation to these issues. So what happens then? I guess 2 points, one of which, if you're trying to draft it, well, I think if you're trying to draft a clause that, because you've got a client who wishes to try and resist it, you need to make it as clear as you can so that there can be certainty as to what act will result in the forfeiture or the other restriction that you're putting in. But what happens if you get a client who is trying to resist a clause or is worried about bringing proceedings in circumstances where there is a clause that may kick in? I have no doubt, and indeed have been involved with them myself, that the most appropriate way, whether it's in a will or a trust, is to take that as a preliminary issue. If they're concerned, then they can go to court for a declaration that the substantive relief does not come within the no contest clause, i.e. the bringing of an Inheritance Act claim would not come within that specific no contest clause. That, of course, would allow the court, in essence, to consider whether the no contest clause is valid without it actually being the decision that is being taken. On that basis, if there is a declaration that the substantive relief doesn't come within the clause, then of course that main claim can be brought. If of course it is declared that the substantive relief would come within the no contest clause, well then of course your client will then have to make the decision as to whether or not they are willing to give up that or potentially give up that benefit in order to bring the claim themselves. Again, this is all the more prudent, almost akin to a Beddoe order in relation to trusts, because of course trusts turn on whether probable cause can be demonstrated. And so again, it's useful to go and seek a declaration as to whether there is probable cause before actually bringing the claim itself. I will stop sharing my screen now if I can. Well, I'm pleased to see so many of you are still here. I haven't completely bored you to death. I hope that's been a useful summary for you all on exoneration clause and no contest clauses. As I said at the beginning, if you have any questions, do please drop us an email, either myself or Nathan, or indeed any member of the probate team. We have another talk coming up on, I believe it's the 6th of September, and details will be sent round to you all shortly. But again, thank you all for joining us, and we hope you've had some interest from it. Thank you very much.